Namaskaram. Welcome to the rapid revision of the Sale of Goods Act 1930. This is CS Rajesh, your log earlier. I hope you guys are doing good and keeping your preparations intact. So let's start with the Sale of Goods Act 1930. If you observe the act name carefully, there are two important terms. First one is sale, second one is goods. Let us understand one by one. The first one is what? Sale. Section number 4 of the Sale of Goods Act 1930 defines the word contract of sale. So what is contract of sale, sir? So it is a contract. So what is contract? An agreement enforceable by law is a contract. So sale of goods or a sale is a contract. It is a what? Contract. In which or whereby a one person called as seller either he transfers or agrees to transfer the property in the goods. So now what do you mean by property, sir? Property means the ownership in the goods. Ownership in the goods. To whom? Buyer. For what? Price. That is called as what? A contract of sale. I repeat, as per section 4, the contract of sale means it's a contract by which the seller either it transfers. So what do you mean by transfer, sir? Means there is an immediate transfer of ownership from seller to buyer, or agrees to transfer means on a future date or after fulfilling the condition precedent. So when a seller transfers or agrees to transfer the property in the goods. So now what do you mean by property? The ownership in the goods to whom? A buyer. For what? A price. It is called as what? A contract of sale. So in a contract of sale, there must be how many parties? Two parties. Who are the two parties? A seller and a buyer. Now who is seller, sir? The one who sells or agrees to sell is called as what? Seller. Then who is buyer? The one who buys or agrees to buy is called as what? A buyer. So we discussed two concepts here. What is contract of sale? It's a contract whereby the seller transfers or agrees to transfer the property in the goods to the buyer for a price. And who is seller? One who sells or agrees to sell, or one who transfers or agrees to transfer. Then who is buyer? The one who buys or agrees to. The next term is the goods. Section 2 subsection 7 defines the word what? Goods. So what is goods? Every kind of movable property. The first key term is goods means every kind of what property? A movable property. So only movable property is considered as what? A goods. So goods means every kind of movable property other than actionable claim. So what is actionable claim, sir? Actionable claim is nothing but a right to recover. A right to recover a unsecured debt. What debt? An unsecured debt is called as what? Called as actionable claim. And actionable claims are covered under which act? Under the Transfer of Property Act. So if you want to transfer a right to file a suit against any other person for recovery of a debt, that can be effected by following which act? The Transfer of Property Act. So goods means every kind of movable property other than what claim? Actionable claim. And money. So money is not governed by the Sale of Goods Act, it is governed by the RBI Act. So money is not considered as an goods. But old currency notes and coins are considered as what? Considered as the goods. So goods means every kind of movable property other than an actionable claim and money. But it includes what? Stocks and shares. Because as per the Companies Act, shares are considered as what? Movable property. The nature of shares, section number 44 of the Companies Act provides that shares are considered as what? Movable property. So it includes stocks, shares, growing crops, grass, as well as things attached to or forming part of the land. The only requirement is that the growing crops, the grass, as well as the standing timbers, they are agreed to be severed. What do you mean by severed? They cut or separated from the land either before the sale or under the contract of sale. That is what called as what? A goods. I repeat, what is goods? Goods means every kind of movable property other than actionable claim and money, includes stock, shares, growing crops, grass, things attached to or forming the part of the land which are agreed to be severed before the sale or under the what? Contract of sale. The next one. The goods can be classified into the following categories for the purpose of ascertaining the transfer of ownership or for the purpose of Sale of Goods Act. What are they, sir? The types of goods. First one is what? Existing goods. Second one, future goods. Third one, contingent goods. Now what is existing goods? If the goods are in possession of the seller at the time of entering into a contract, it is called as what goods? Existing goods. I repeat, if the goods are owned or possessed by the seller at the time of entering into a contract, it is called as what? Existing goods. Then what are future goods, sir? The goods which are yet to be manufactured or produced is called as what? A future goods. They are not in existence at the time when the contract is made. Now what is contingent goods, sir? The acquisition of the goods by the seller depends upon the happening or non-happening of a certain contingent event. That is called as what? A contingent goods. If a chair, for example, this pen in existence, this is called as what? Existing goods. Now what if I agree to manufacture and sell? I made a contract to sell the future goods. Then what if I enter into a contract with a condition that if my friend sell this to me, I will sell it to you. That is called as what goods? Contingent goods. So goods can be classified into three categories: existing goods, future goods, contingent goods. If the goods are in possession of the seller at the time of contract, existing goods. If they are yet to be manufactured or produced, future goods. If the acquisition of the goods depends upon the happening or non-happening of an uncertain event, that is called as what? Contingent goods. So this existing goods can be again classified into how many types? Three types: specific goods, unascertained goods, ascertained goods. What is specific goods, sir? The key terms are: if the goods are identified and agreed upon at the time of entering into a contract itself, it is called as what goods? Existing goods. Let's say there is a bulk of 100 bags of sugar. Out of 100 bags of sugar, the buyer select the 10 bags of sugar. Then he enters into a contract. He made a contract to purchase what goods? Specific goods. I repeat, if the goods are identified and agreed upon either before or at the time of entering into a contract itself, it is called as what goods? A specific goods. Then next one is what? Unascertained goods, the opposite to specific goods. If a person enters into a contract without identifying the goods or without agreeing the specific goods, it is called as what goods? Unascertained goods. For example, in the go down, there are 100 bags of sugar. Out of that, you enters into a contract to purchase 10 bags of sugar. Those 10 bags are not identified yet, but the contract is already made, so it is called as what goods? Unascertained goods. Then comes the ascertained goods. So what is ascertained goods, sir? After the contract is made to purchase the unascertained goods, when the seller or the buyer, with the consent of other party, appropriate the agreed quantity of the goods from the bulk, so that appropriated goods becomes what? Becomes the ascertained goods. I entered into a contract to purchase 10 bags of sugar out of 100 bags of sugar, which are not identified yet. So it is a contract for sale of unascertained goods. So after the contract is made, either the seller with the consent of the buyer or the buyer with the consent of seller appropriate. Now what do you mean by appropriate? Selection or bifurcation from the bulk. So when we separate the 10 bags of sugar, the 10 bags becomes what? Ascertained goods. So these are the types of goods. I repeat, there are three types of goods: existing, future, contingent. If they are possessed or if they are in possession of the seller at the time of contract, existing goods. Yet to be manufactured or produced, future goods. Receipt of which depends upon the happening or non-happening of an uncertain future event, contingent goods. Existing goods, again how many types? Three types: identified and agreed upon, specific goods. If the goods are not identified and agreed upon at the time of contract, unascertained goods. If the goods are, once the contract is made, if the goods are appropriated from the bulk with the intent of applying them in the contract of sale, that becomes what goods? Ascertained goods. Out of all these types of goods, there can be an immediate transfer of ownership only in the specific goods or ascertained goods as per section number 18 of the Sale of Goods Act 1930. So till now, I discussed two concepts. First one is, what is contract of sale? What is contract of sale? It's a contract in which seller transfers or agrees to transfer property in the goods to the buyer for a price. That is called as what? Contract of sale. How many parties? Two parties. Who are the two parties? Seller, buyer. Who is seller? The one who sells or agrees to sell is called as what? Seller. Then who is buyer? The one who buys or agrees to buy. Then we discuss the definition of goods. So what is goods? Goods means all kinds of movable property other than actionable claim and money, but includes what? Stock, shares, growing crops, grass, things attached to or forming part of the land, but which are agreed to be severed before the contract of sale or under the contract of sale. Types of goods, there are three types of goods: existing goods, future goods, contingent goods. Existing goods, again how many types? Three types: specific goods, unascertained goods and ascertained goods. Then section number 4 further provides the essential elements of a valid contract of sale. So what are the essentials, sir? So there are six essential elements of what valid contract of sale. First one is what? Two parties, obviously seller and buyer. Who is seller? The one who sells or agrees to sell is called as what? Seller. Then who is buyer? One who buys or agrees to buy. Next one, subject matter of the contract of sale is always what? Goods. Obviously it is which act? Sale of goods act. The subject matter of the contract of sale must always be the goods, but the goods can be what? Goods can be existing goods, future goods, or contingent goods. Next one, there must be consideration. Without a consideration, there can't be a contract of sale. If it is no consideration, if there is no consideration, it is considered as what? Gift. And it is not covered under the sale of goods act. There has to be a consideration in terms of money, not in the barter system. Next one, there must be a transfer of property, the absolute transfer of property. So what do you mean by property, sir? Ownership. If just a right to use the goods is transferred, it is not considered as a sale of goods. For example, bailment, hire purchase, they are not considered as a sale. It is considered as a sale only when the absolute ownership is transferred from seller to the buyer. Means all the bundle of the rights should be transferred from whom? Seller to the buyer. Next one, the contract of sale must be may be absolute or conditional. The seller can impose as many conditions as he wish. If the buyer agrees for them, then the contract is valid. And most important, it must also satisfy what? All the essential elements of section number 10 of the Indian Contract Act 1872. So these are the essentials of what? A valid contract of sale. Next one, section number 5 provides the formalities of contract of sale, means how the contract of sale is made. A contract of sale is made by an offer to buy or sell and acceptance of such offer by the another person. So obviously there must be minimum how many parties? Two parties. If they ask any question about section number 5 in the examination, you must write the contract of sale. COS means what? A contract of sale. A contract of sale is made by an offer to buy or sell and acceptance of such offer by whom? By the other party. And in that contract, the parties can agree that there can be an immediate delivery of goods. They may agree immediate delivery of goods, and the date of contract itself, the goods will be delivered. Or they may agree that immediate payment of price, but delivery on what date? On a future date. Or they may agree that there may be an immediate delivery as well as what? Immediate payment. Both are happening at the same time. Or they may agree that the delivery and payment happens on what basis? The installment basis. And the next one, or they may agree that delivery and payments are postponed to what date? On the future date. For example, if today we are entering into a contract, we may agree that I will deliver after 2 days and you will make payment after 3 days. Is it valid? Yes, it is valid. And it is left to the parties to decide the terms of contract of sale. This is how the contract of sale is made. Keep this in mind. A contract of sale is made by an offer to buy or sell by one person and the acceptance of such offer by the another person. There can be immediate delivery of goods, immediate payment but delivery on a future date, immediate delivery but payment on a future date, delivery and payment in installment basis, or both are postponed to the future date. Section number 5. Section number 6, subject matter of the contract of sale. The subject matter of the contract of sale is always what? Goods. And we discussed the definition of goods. Goods can be existing goods, future goods, contingent goods. And we also discussed the definition of existing goods, future goods and contingent goods. Section number 6. Section number 7 and 8 are most important in the previous examination. If they ask questions about in the first unit, they generally ask questions based on section number 7 and 8. 7, 8, 9, 10. These are the section numbers which are important from the examination point of view. What is section number 7? Section number 7 deals with the goods perishing before making the contract. If the goods perishes before making the contract, then what are the consequences? When I say perishment, perishment includes the loss of goods by theft or acquisition of goods by the government or any destruction of the goods. So if the goods are perished before making the contract, that is before risk passes to the buyer, then what are the consequences? It is considered as a mistake of fact and the agreement is void. I repeat, where there is a contract for sale, sale of what goods? Specific goods. Keep this in mind. Section number 7 is applicable only for the sale of specific goods. If there is a contract for the sale of specific goods, then the contract is what? Void. So when the contract is void, sir? The contract is void if without the knowledge of the seller at the time of contract, the goods have been perished. or they are no longer answerable to the description made in the contract. Means if you describe something as butter, but if the butter has become ghee, is it corresponding to the description made? No, it means it is perished. When the contract is void, the buyer is not bound to accept the goods. Section number 7. I repeat, it's a contract when there is a contract for sale of what goods? Specific goods. When the contract becomes void, in what scenario? Without the knowledge of the seller at the time of contract, if the goods are perished or damaged, no longer to answer to the description in the contract. Section number 7. Section number 8, goods perishing before sale but after agreement to sale. If the goods have perished before the sale but after the agreement to sale. Sir, what is the difference between sale and agreement to sale, sir? In case of sale, the ownership is transferred immediately from seller to the buyer. But in case of agreement to sell, the ownership is transferred on a future date or after fulfilling the condition precedent. So you made an agreement, but ownership is not transferred to the buyer. In that scenario, if the goods are perished, what are the consequences? So, if there is an agreement to sell, again, what goods? Specific goods. Keep this in mind. Section 7, Section 8 is applicable only when there is an agreement to sell what goods? As specific goods. And if the subsequently, without the fault of seller, without the fault of whom? The seller or the buyer, if their goods are perished or damaged, no longer to answer to the description, before the risk passes to the buyer, then the agreement becomes void. So these are the keywords. Agreement to sell, specific goods. You have to mention this word called as specific goods. Section number 7, 8, specific goods. Agreement to sell, specific goods. Subsequently, without the knowledge of seller or the buyer, or without the fault of seller or buyer, goods are perished or damaged, no longer to answer to their description. Before risk passes to the buyer, the agreement becomes what? Void. It means the buyer is not bound to accept the goods and seller is the one who is responsible to bear those losses. So 7, before contract itself, if the goods have been perished, without whose knowledge? Seller's knowledge, void. 8, after agreement with before sale, that is before sale means ownership is not transferred to the buyer, and without fault of seller or buyer, what happens? Agreement is void. Section number 9, ascertainment of price. How to fix the price of the goods in the contract, or how it is ascertained. The price in a contract of a sale may be fixed by the contract itself, means the parties can agree the exact price in the contract itself, or may be left to be fixed in the manner thereby agreed, means they can fix the manner of fixing the price in the contract. For example, I am entering into a contract with you and I am agreeing that the price to be fixed, the price of the goods which I am selling it to you, will be the cost plus 10% of profit. Am I agreeing the exact price here? No, I am agreeing how to fix the price. Or what if I say I will sell the goods at a market price? So we can fix the price as per which price? Market price. So parties either can fix the price of the goods in the contract itself, or they can fix the manner of fixing the price, or it may be determined based on what? Course of dealing between the parties. Now what is course of dealing, sir? The course of dealing means the practices or the price at which the party usually sell and the other party usually buy. That is considered as what? A course of dealing. So these are the 3 ways in which the price can be fixed or ascertained in the contract of sale. The price in a contract of sale may be fixed by the contract itself, or may be left to be fixed in the manner thereby agreed, that is in the contract, or may be determined by the course of dealing between the parties. When the price could not be ascertained as per the foregoing provision, means as per the above 3 methods, in that scenario, if the buyer has accepted the goods, he must pay a what price? A reasonable price. To whom? To the seller. I repeat, if the price could not be determined as per the foregoing provision, means as per the above 3 methods, in that scenario, if the buyer has accepted the goods, the buyer should pay what price? The reasonable price to the seller. Then section number 10, important one, in the recent MTP mock test paper, they asked question based on section number 10. If there is an agreement to sell at valuation, so valuation of shares, valuation of goodwill is the one of the important area where CA works, correct, right? So if there is an agreement to sell at a valuation, I am entering into a contract with you to sell my goods at a price to be valued and fixed, at a price to be fixed by a third party. In that scenario, what would be the consequences if he fixes the price? What will be the consequences if he does not fix the price or refuses to fix the price? So let's discuss. If there is an agreement to sell the goods on the condition that the price to be fixed by the valuation of a third party, a stranger. In that scenario, if the third party cannot fix the price or he cannot does not make such valuation, then the agreement is what? Void, because there is no price. But third party is prevented from making the valuation either by the fault of seller or the buyer. Then the party in fault should compensate whom? The party who is not in fault. Correct, right? These are the consequences of agreement to sell the goods at a valuation by third party. I repeat, if there is an agreement to sell the goods on the term that the price to be fixed by the valuation of a third party, if the third party cannot or does not make such valuation, the agreement is void. If a third party is prevented from making such valuation by the fault of seller or the buyer, then what happens? The party not in fault can sue for the damages. Section number 10. Most important, when the third party cannot or does not make such valuation, the agreement is void. But if the goods are already delivered to the buyer and the buyer has already appropriated the goods, what do you mean by appropriated the goods? He has used the goods. In that scenario, for the goods which he has used, must pay what price? A reasonable price. Then section number 11. Section number 11 provides what? Stipulation as to time. What is stipulations are? Nothing but the terms. In the law language, we call them as what? As stipulations. Stipulation as to time. Unless a different intention appears in the contract, a stipulation as to payment of price. Stipulation means the term. The term with respect to payment of price is not the essence of the contract. It means even if the payment is not done on time, the seller cannot repudiate the contract. The only remedy is what? He can sue for damages, or he can give a notice that he's going to resell it to somebody else, and he can resell it. I repeat, in a contract of sale, unless there is a different intention appears in the contract, means the parties are not agreed anything to the contrary, law provides that for payment of price, time is not the essence. For other things, it depends upon the terms of the contract. Correct, right? For example, section number 55 of the Indian Contract Act 1872 provides that time is the essence of the contract for delivery of goods. So we can consider that for delivery of goods, what is the essence? Time is the essence. But for payment of price, time is not the essence. But what if it is agreed in the contract that time is the essence even for the payment of price? Then the time becomes essence, and if the goods payment is not done on time, the seller can cancel the contract. Clear? So these are the topics of unit 1. So I discussed what is sale, goods, types of goods. Then we discuss section number 4, that is what is contract of sale and essentials of contracts of sale. Section number 5, we have discussed section number 5, that is with respect to how the contracts are formed, that is how the sale is made. Section number 6 is the goods, that is subject matter of the contract of sale of goods. And section number 7, perishment, that is before contract perishment. 8 is also a perishment, that is before sale perishment. What are the consequences? 9, to ascertain the price. 10 is a valuation, sale at valuation of a third party. And 11 is the time and stipulate the time. Next one, second unit, most important unit, one of the most important unit, that is conditions and warranties. Section number 12 defines the word conditions and warranties. So what is conditions and what is warranties? Warranties, sir. See, in a contract, when I take into consideration a contract of sale of goods, in that contract, parties will agree so many terms. Correct, right? Seller will say something, buyer will say something. It can be about description, it can be about quantity, it can be about quality, it can be about color, it can be about many things, specification, many things. Out of those stipulations or terms, some are more important, some are less important. Like human body may, there are so many organs. Some are most important, the vital parts. Some are less important. People can survive even if they don't have such organs. So in the same way, in the contract, there will be stipulations, nothing but the terms, out of them which are essential to the main purpose of the contract. They are the core of that contract of sale. So if a stipulation which is essential to the main purpose of the contract, and if that stipulation is breached or broken, then the other party has the right to cancel the contract and sue for damages. That is called as what? Condition. But the stipulation, the other stipulation, the remaining terms which are not so essential, they're just a collateral to the main purpose of the contract, and breach of which gives the aggrieved, the opposite party, just to right claim compensation. That is called as what? A warranties. I repeat, stipulations are nothing but the terms agreed by the parties to a contract. These stipulations can be classified into how many types? Two types. One, the stipulation which are what? Essential to the main purpose of the contract. The stipulation which are essential to the main purpose of the contract, the breach of which gives the aggrieved the two remedies, right to repudiate the contract, that is to cancel the contract, and sue for damages. That is called as condition. Then the stipulation which are collateral to the main purpose of the contract, the breach of which gives the aggrieved the only right to claim the damages, is called as what? Warranties. Condition, two remedies. Warranties, one remedy, that is right to claim the damages. So this section number 13, most important section based on which they ask question many times. There are few cases where a condition sinks to the level of warranty. Means a condition becomes what? Becomes a warranty. Sir, what are the cases in which a condition becomes warranty, sir? There are three scenarios. How many scenarios? Three scenarios. What is the first one? If there is a contract for sale, subject to some condition to be fulfilled by the seller, and if the seller fails to fulfill those conditions, the buyer may waive the condition. What do you mean by waive? Give up that condition. Or he may elect to treat the breach of condition as what? Breach of warranty at his own option. So when the buyer elects to treat the breach of condition as a breach of warranty, then the condition becomes what? Warranty. Condition becomes what? Warranty. I repeat, the contract of sale is subject to any condition to be fulfilled by the seller. The buyer may, at his own option, either may waive the condition or elect to treat the breach of condition as what? Breach of warranties. Next one, second scenario in which a breach of condition is considered as breach of warranty is where there is a contract for sale, and if it is not severable, and not severable means what? It is not sufferable, and the buyer has accepted the goods. Most important, first one is when he has waived the performance of the condition or he has elected to treat the breach of condition as breach of warranty. Second one is if the contract is not severable and the buyer has accepted the goods. In that scenario, a breach of condition becomes what? A breach of warranty. So when can we say a person has accepted the goods? A person has deemed to have accepted the goods in the following scenarios. As per section number 42 of the Sale of Goods Act 1930, a person deemed to have accepted the goods when he intimates to the seller that he has accepted the goods, or if he does anything which is inconsistent with the ownership of the seller, that is when he pledges the goods, or when he consumes the goods, or if he destroys the goods, or if he resells the goods. All these are an act which is inconsistent with the ownership of the seller. Last one, in case of lapse of reasonable time, if he keeps the goods either beyond the prescribed time or beyond the reasonable time without intimating the rejection, then also it is considered as what? Acceptance. So first one is expressed acceptance. The last two are what? Implied acceptance. So what is the first one is waiver or election to treat breach of condition as breach of warranty. Second one, when the goods are not severable and the buyer has accepted the goods. And third one is the most important one, where the fulfillment of any condition or a warranty is excused by what? Excused by the law of, because of a reason of impossibility. If the fulfillment of any condition or a warranty is excused by the law itself says even if you don't fulfill those conditions or warranties, it is excused, you're not liable, then the condition becomes what? Warranty. Section number 13, and there are only how many situations? Three situations. Keep this in mind. Section 13, a breach of condition can be considered as what? A breach of warranty. What is the first one? Waiver or election. Second one, contract not severable, buyer has accepted the goods. Third one, fulfillment of condition is what? Excused by the reason of impossibility, by the law itself. Next, we have the implied conditions and warranties. See, these conditions and warranties in the contract of sale can be classified into two categories. The first one, expressed conditions and warranties. Second one, implied conditions and warranties. The conditions and warranties which are agreed by the parties in the contract itself, that is called as what? Expressed conditions. Then we have one more category called as implied conditions. The conditions which are presumed to be there in the contract of sale or which are imposed by the law. They are called as what? Implied conditions and warranties. These expressed conditions and warranties will change from contract to contract, but the implied conditions and warranties remains the same in each and every contract of sale. So let us discuss one by one what are the implied condition, what are the implied warranties. First one, section number 14. The first implied condition is what? Condition as to title. Condition is what? Condition as to title. Now what is condition as to title, sir? This condition provides that the first implied condition, it is a what condition? The first implied condition in a contract of sale is that in case of sale where there is immediate transfer of ownership, in case of sale the seller must have the right to sell the goods when he sell the goods, and if he is entering into a contract of agreement to sell, then he will have a right to sell the goods at the time when the property is to pass from seller to buyer. So this first condition, that is condition as to title, requires that in case of sale, the seller must have a right to sell the goods, and in case of agreement to sell, he will have a right to sell the goods at the time when the property is to pass. What is property? Ownership is to pass from seller to buyer. What if a seller sell the goods? That is, it enters into a contract to transfer ownership without having a right to sell it. Is that agreement valid or void? It is voidable at the option of buyer. The buyer can cancel it and sue for damages because it is a breach of condition. So violation of trademarks, then selling goods without ownership. These are the examples for condition as to title, section number 14. I repeat, the first implied condition is that condition as to title, which provides that in case of sale, the seller must have a right to sell the goods, and in case of agreement to sell, he will have a right to sell the goods at the time when the property is to pass. If not, then the buyer has the option to cancel the contract and sue for damages. Next one, sale by description. When the goods are sold by description, the implied condition is that the goods shall correspond with what? Correspond with description made. If the goods does not correspond with the description made, it amounts to what? A breach of condition. The buyer can cancel it. If you say it's a Darjeeling tea, it should be Darjeeling tea. If you give Chikmagalur tea, is it valid? No, it is not valid. If you describe something as Tirupati Laddu, but you give Bangalore Laddu, is it valid? No, totally different. So if there is any description made in the contract of sale, then the goods shall correspond with the description. If not, the buyer can reject the goods even if he had inspected the goods, because it is the fundamental conditions. So even if he has inspected the goods, but the goods are not corresponding with description, who can cancel the contract? The buyer can cancel the contract. Next one, goods, sale of goods by sample as well as description, section number 15. When the goods are sold by sample as well as description, the goods must satisfy or correspond with the sample as well as description. If I am giving a sample of some oil, but I describe it as sunflower oil, so I am supplying the oil which is corresponding with sample, not with description. Is it valid? No. If whenever there is a sale by sample as well as description, the goods supplied shall correspond with the sample as well as the description. Section number 16, the important one. Most of the questions are asked based on this condition itself. Where there is a condition has to quality or fitness. See, in general, caveat emptor, let the buyer be aware. It is not the duty of the seller to supply the goods suitable for the buyer purpose. It is whose duty then? Buyer's duty. He should be careful enough to select the goods suitable for his purpose. But there is an exceptional scenario where if the buyer satisfies these three conditions, then this condition is applicable. So we can impose the section number 16 condition only when the contract satisfies how many conditions? Three conditions. What are they? First condition, the buyer should make the seller aware about the purpose for which he needs the goods. So the buyer should intimate to seller for what purpose he is buying the goods. Second one, the buyer should rely upon the skill and judgment of the seller. So he is trusting the seller, believing that seller is the one who is capable of supplying the best goods. And the last one, the one who is supplying the goods to him should be dealing with the goods of that particular description. Means the seller is regularly selling that goods, whether he is manufacturer or not. If these three conditions are satisfied, then the burden shifts on whom? Shifts on the seller. What is the first one? The buyer should have made the seller aware about the purpose. Second one, the buyer relies upon the skill and judgment of the seller, and the goods must be of the description dealt by the seller, whether he is a manufacturer or not. Next one, condition as to what? Merchantability. Condition as to what? Merchantability. So what is merchantability, sir? Commercial value. What is the reason of buying the washing machine? To wash. That is the commercial value of the washing machine. So whenever we purchase something by description, washing machine is a description. It must wash. Now what if it is not washing? It is a scrap. So if it is not corresponding with the description, that means it is not having what quality? A merchantable quality. Then the buyer has the option to cancel and sue for what? Damages. Next one, sale by sample. Section number 17 provides the provision with respect to sale by sample. See, sale by sample 7. Yes, section number 17. Name logic, but it works. It works in most of the cases. 17. Perishment of goods, specific goods. S 7. Here 7, it is 17. Sale by sample. So when there is a sale by sample, there are three conditions to be satisfied. What is the first one? The bulk shall correspond with the sample in quality. Whatever the bulk supplied should correspond with what? Sample in its quality. Second one, the buyer should have the reasonable opportunity of comparing them with a bulk, so comparing the bulk with the sample. So what if the seller does not allow the buyer to inspect them? Then the buyer can reject the goods and sue for damages. It's a breach of condition. So there are three conditions, right? First one, the bulk shall correspond with the sample. Second one, the buyer should have given the reasonable opportunity to inspect the goods. And the third one, the goods shall be free from the defects which render them unmerchantable. Nothing but latent defects. The defects in the goods can be classified into two categories: latent and the patent. Latent defects are the one which cannot be discovered by ordinary diligence. Patent are the one which can be discovered by ordinary diligence. So the goods should be free from what defects? Latent defects, even the goods are purchased by a sample. Next one, condition as to wholesomeness. So this is applicable in case of what? Eatables and provisions. When there is a sale of eatables or provision, there is an implied condition that the goods shall be what? Fit for human consumptions. If they are not fit for human consumption, a breach of condition, buyer can cancel and sue for damages. 7 implied condition. What are the 7 implied condition? Condition as to title, condition as to sale by description, sample as well as description, quality and fitness, then sale by sample, then condition as to wholesomeness, and condition as to merchantability. So these are the implied conditions. Keep this in mind. There may be one question. Last examination, they asked implied warranty. Section number 14B, 14C, and section number 16.3. What is implied warranty, sir? The warranties which are deemed to be part of the contract of sale is called as what? Implied warranties. In case of warranties, a breach of warranty, there will be how many remedies? One remedy. What is the one remedy? You can claim only what? Damages. 14B provides that warranty has to undisturbed possession. See, what is the reason of buying the goods? To enjoy it peacefully without any disturbances. What if there is a disturbance in the possession of the buyer because of the fault of the seller? Breach of warranty. Buyer can sue the seller for recovery of damages and loss and any inconvenience of it. Next one. Warranty has to non-existence of encumbrances. So what is encumbrances, sir? Any charge or impediment or any hurdle created on the assets or a goods is called as what? Encumbrances. See, when we sell the goods should be free from what? Any charge or encumbrances. If there is any charge or encumbrances and that is not disclosed to the buyer at the time of entering into a contract of sale, it's a breach of warranty. The buyer can sue the seller for recovery of what? Damages. Next one, warranty has to what? Quality or fitness by usage of trade. What is usage of trade? Practices. If there is any practices in certain trade which are known to both the parties, they become part of the contract and even those terms to be satisfied. If not satisfied, the buyer can sue the seller for recovery of damages. Fourth one, disclose the dangerous nature of goods. Important hai, if the seller is aware about the fact that the goods are of dangerous nature or may cause harm to the buyer, then the seller should disclose it to whom? Buyer. If it is not disclosed or sufficiently warned, that is why you observe on every product, right? Warning, keep it away from children. So if there is no disclosure of dangerous nature of goods and if the buyer suffers the loss, then who should compensate? The seller should compensate the buyer. So these are the 4 implied warranties. Warranty has to undisturbed possession of the goods. Warranty has to non-existence of encumbrances. Then warranty has to quality and fitness by usage of trade. And the fourth one, a disclosure of dangerous nature of goods. So these are the implied conditions and implied warranties. 7 implied conditions and 4 implied warranties, based on which we can expect one question in the examinations. And you have to use these key terms to present your answer if they ask a practical question. Clear? Yes. Next one, section number 16, a doctrine of caveat emptor. Doctrine of what? A caveat emptor. Now what is caveat, sir? Caveat means a caution. What is emptor? Emptor means buyer. So it is a caution. Caution to whom? Caution to the buyer. Section numbers provides that it is the duty of the buyer to make sure that he inspect the goods and he purchase the rightful goods suitable for his purpose. What if buyer does not make the proper inspection and he purchases the wrong goods? Is the seller responsible? No. It's a mistake of unilateral mistake. Then who is responsible? Buyer responsible. So if buyer makes a wrong choice, who is not responsible? Seller is not responsible. However, section number 16 is subject to provisions of this act. There are few exceptional cases where the burden shift on whom? Seller. Implied condition as to quality and fitness for buyer purpose, if those three conditions are satisfied. Correct now? Or any other law. What is any other law? We have a COPRA, Consumer Protection Act, where the burden is shifting from whom? Buyer to the seller. Now even the seller is supposed to what? Provide the detailed information. So subject to the provisions of this act or any other law, there is a no implied condition as to warranty as to the quality or fitness for buyer purpose. It means whose responsibility? A buyer responsibility. But in the following cases, the responsibility shifts on whom? On the seller. So the principle of caveat emptor is not applicable in the following exceptional cases. What are they? First one, fitness as to what? Quality or use. If the buyer made the seller aware about the purpose for which he need the goods, he relies upon skill and judgment of the seller, and the seller is dealing with the goods, the seller is now responsible to supply the goods suitable for whose purpose? Buyer purpose. Second one, goods purchased under the patent or a brand name. You are paying a premium money. Why are you paying the premium money? Because you are expecting some quality. If those quality conditions are not met, you can cancel the contract. Next one, goods sold by description. The goods shall correspond with what? Description. Merchantable quality. When the goods are sold by description, the goods shall be of what quality? A merchantable quality. Next, goods sold by sample. Three conditions. What are three conditions? Correspond with sample, reasonable opportunity to compare them with the bulk, free from latent defects. Next one, sample as well as description correspond with both. Any conditions imposed by trade usages, even those conditions are to be fulfilled. And the last one, when the seller actively conceal the defect or is guilty of fraud. So in these cases, what cases? In these cases, the principle of caveat emptor is not applicable. So we covered till section number 16, not 16, section number 17 of the Sale of Goods Act. Unit 3, transfer of ownership and delivery of goods. What is the importance of ascertaining the point of transfer of ownership from seller to the buyer? The first reason or the first importance is to ascertain the risk, transfer of risk from seller to the buyer. Because the risk always goes with what? Ownership. If the ownership is transferred, then what is transferred? The risk is transferred from seller to the buyer. That is the first reason. Second reason, action against third party. See, if the ownership is transferred by whom? From the seller to the buyer, then buyer can file a case against whom? Against anybody. If ownership is not transferred, the buyer can only sue whom? Seller. He cannot sue the third parties. So a sale creates right in rem, right against anybody. Third reason, seller right for price. So if the ownership is transferred to the buyer, then who can file a suit for price? Seller can sue the buyer for a price. If ownership is not transferred, he can only recover damages. Last one, the important one, effect of insolvency. See, if the ownership is transferred to the buyer and if the buyer becomes insolvent, seller has a risk of loss. If ownership is not transferred, then is there any risk of insolvency on the seller? No. But if the ownership is transferred and seller becomes insolvent, is there any risk of insolvency on the buyer? No. If ownership is not transferred, seller becomes insolvent, then who has the risk of insolvency? Buyer has the risk of insolvency. To ascertain the risk of insolvency or the right for a price or action against third party, or at what point of time the risk is transferred from seller to the buyer, what is important? Ascertainment of transfer of ownership is important. So for transfer of ownership, what is the most important thing? The goods must be ascertained. We can transfer ownership only in the what goods? Ascertained goods or specific goods. In case of future goods, contingent goods, there can only be an agreement to transfer ownership, not the transfer of ownership. Section number 18. Section number 19. Transfer of property in specific or ascertained goods. In case of specific goods or ascertained goods, at what point of time ownership is transferred? See, just keep this in mind. In case of contract of sale of goods, the ownership is transferred as per whom? As per the intention of the parties. As per whom? Intention of the parties. Only when the intention is not clear, we have to apply section number 22 then 25 to ascertain at what point of time the ownership is transferred. Section number 19 clearly provides that the ownership in the goods, specific goods and ascertained goods are transferred at the time when the parties intended it to be transferred. That is as per the intention of whom? Parties. Section 20. Section 20 to 25 provides what? The situations when the intention is not clear in the contract. Means the parties have not agreed at what point of time the ownership is to be transferred from seller to buyer. In those cases, we have to apply these rules to the given scenario and ascertain at what point of time the ownership is transferred. Section number 20 deals with a situation where there is a contract for sale of specific goods and the goods are in deliverable state, and if it is an unconditional contract. In that scenario, the law provides that the ownership is transferred from the seller to the buyer when? Immediately. That is at the time of entering into a contract itself. If ownership is transferred, risk is transferred. If something happens to the goods, then who is responsible? Buyer is responsible. Repeat. Section number 20, specific good, deliverable state, unconditional. When the ownership is transferred? Immediately. That is at the time of entering into a contract itself. 21. Sale of what goods? A specific good. Put into what state? A deliverable state. Sale of specific good put into deliverables which are required to be put into deliverable state. In that scenario, when the ownership is transferred, in case of sale of specific goods and the seller is bound to do something to put them into deliverable state, the ownership is transferred only when the goods are put into what state? A deliverable state, and it is informed to whom? Buyer. I repeat, sale of specific goods, but they are not in deliverable state. Means there is something need to be done to put them into deliverable state, like putting them into separate bags or separate bottles. So when the ownership is transferred, the property is transferred when such pending thing is done, plus it's informed to whom? Informed to the buyer. 22 SG. SG means what? Specific goods. Specific goods, deliverable state, and seller has to do something to ascertain the price. If seller is required to do something to ascertain the price, in that scenario, the ownership is transferred when the seller does such things to ascertain the price and it is informed to the buyer. What is transferred? Ownership is transferred. What are the keywords for this section number? Specific good, deliverable state. Seller is bound to either weigh them, measure them, test them, or to do some other act. In that scenario, ownership is transferred when such thing is done. That is, weighing, measuring, testing, or some activity has been done, and it is informed to whom? Buyer. Section number 22. 23 important one. Based on this, they asked question in the recent MTP. Sale of unascertained goods. Can we sell unascertained goods? Yes, there can be an agreement to transfer ownership in case of what goods? Unascertained goods. Listen, pure logic, simple. In case of sale of unascertained goods or a future goods by description. Remember, sale of unascertained goods or a future goods by description. Then the ownership is transferred in such goods when the goods of that particular description in a deliverable state. What state? A deliverable state. Unconditionally appropriated to the contract either by the seller with the consent of the buyer or by the buyer with the consent of seller. I repeat, in case of unascertained goods, the ownership is transferred. When it is transferred? When the goods of the description in the contract and which are in deliverable state, unconditionally appropriated. Most important, we will discuss when it is considered as unconditionally appropriated. Only when it is unconditionally appropriated to the contract either by the buyer with the consent of seller or by the seller with the consent of the buyer. What is transferred? Ownership is transferred. Last time I repeat, in case of sale of unascertained goods are future goods by description. The ownership is transferred in them when the goods have that description in a deliverable state, unconditionally appropriate to the contract by the seller with the assent of the buyer or by the buyer with the assent of the seller. Now the question is, what is appropriation? Appropriation means selection of the goods with the intent of using them in the performance of the contract. The selection can be done either by putting a mark on the goods or by physical separation or by any identification method. And that appropriation to be done by the whom? The seller with the consent of buyer or by the buyer with the consent of seller. Next one more important provision, delivery of goods to the carrier. So when the goods are delivered to the carrier or to a buyer to be delivered to the seller, in that scenario, who will be having the risk of loss or when the ownership is transferred? I repeat, as per the contract, when the seller delivers the goods to the whom? Buyer or a carrier or other bailee for the purpose of transmission to the buyer, and if the seller does not reserve the right of disposal, means he is not having the control over the delivery of goods to the buyer. In that scenario, it is considered unconditional appropriation of goods or unconditional delivery of goods to the carrier. I repeat, this is a delivery of goods by seller to the buyer or carrier or other bailee, and he is not reserving the right of disposal. That is called as unconditional appropriation of goods. So when the seller unconditionally appropriate the goods to the carrier for the purpose of it to be delivered to the buyer, in that scenario, the carrier acts as whose agent? Buyer's agent. The ownership is transferred from the seller to the buyer immediately. Means the carrier acts as whose agent? The buyer agent. I repeat, seller delivers the goods to the buyer or carrier or other bailee for the purpose of what? Transmission to the buyer, and he does not reserve the right of disposal. That is called as what? Appropriation, unconditional appropriation. So when the goods are unconditionally appropriated by the seller to the carrier, then carrier acts as whose agent? Buyer's agent. The ownership is transferred immediately. Means the moment the seller gives the goods to the carrier, what is transferred? Ownership is transferred to the buyer. So now the question is, when can we say the seller has reserved the right of disposal? When can we say the seller has not reserved the right of disposal? Because if seller reserves the right of disposal, then it is conditional appropriation. When he does not reserve the right of disposal, unconditional appropriation. Only if it is unconditionally appropriated, the delivery of goods to the carrier acts as delivery of goods to the buyer itself. But if it is conditional appropriation, then the carrier acts as whose agent? By a seller agent itself. So then who is responsible? Seller is responsible. In the following two scenarios, the seller is presumed to have reserved the right of disposal. If the seller has reserved the right of disposal, then the ownership is not transferred to the buyer unless until the goods are delivered to whom? Delivered to the buyer. So in what scenario the seller has been to have reserved the right of disposal? I expect them to ask question based on this topic in the upcoming examination. So seller is presumed to have reserved the right of disposal. First one is what? When the goods are delivered to a railway administration for carriage by bill of lading or railway receipt, plus the goods are deliverable to the order of seller or his agent. Important. The carrier is supposed to deliver the goods as per the instructions of seller or seller's agent. That means the seller has reserved the right of disposal. That means the carrier is the agent of whom? Seller. That means the goods are conditionally appropriated, and that means the buyer will not become the owner correct, unless until who receives the goods? Buyer receives the goods. Second scenario, where a seller draws a bill, the bill of exchange on the buyer for a price or for his acceptance, and he sends the bill of exchange along with the bill of lading. In that scenario, the buyer must return the bill of lading if it does not accept or pay the bill. So if it does not pay the bill, it means he is not transferring. So in both the scenarios, the seller is deemed to have reserved the right of disposal. If he has reserved the right of disposal and delivered the goods to the carrier, it is called as conditional appropriation. The ownership is not transferred to the buyer. Only when the seller delivers the goods to the carrier without reservation of right of disposal, it is called as unconditional appropriation. Then only who becomes the owner? Buyer becomes owner immediately the moment goods are delivered to the carrier, because carrier acts as whose agent? Buyer's agent. Next one, section number 24, the goods sent on approval basis or return basis. In this situation, when the goods are sold on approval or return basis, the ownership is transferred when the buyer gives acceptance. And that acceptance can be expressed or implied. So when can we say it is acceptance, or when he intimates, who intimates? The buyer intimates to sellers that he has accepted the goods, or he does anything adopting the transaction, like consumes the goods or breaks the goods. That is considered as what? Acceptance. Second one, if he has kept the goods until the lapse of prescribed time or the reasonable time. Acceptance, the ownership is transferred. Third one, he has does something to the goods which is equivalent to accepting the goods. That is, if he pledges the goods or destroys the goods, that is also considered as what? Considered as the acceptance. And what is transferred? The ownership is transferred from seller to the buyer. So these are the cases in which the ownership is transferred from seller to the buyer in case of sale of goods on what basis? Approval. The next topic is section number 26, transfer of risk. The general rule is that the risk always goes with the ownership, and the risk remains at the seller unless the property is transferred to the buyer. But however, there are two exceptional cases where the risk is transferred other than with the ownership. First one is what? Delay in delivery. If the delivery of the goods is delayed by the fault of any of the parties, then the party under fault is the one who is liable to bear the risk of loss, even though ownership already transferred. Next one, if the parties have agreed to separate the risk from the property, they have clearly agreed that the risk is transferred different from the date of transfer of ownership. In that scenario, the risk is transferred other than with the ownership. These are the two exceptional cases. Next one, important topic, section number 27 to 30 deals with transfer of title by non-owners. That is nemo dat quod non habet. What is nemo dat quod non habet? No one can give what he has not got. If seller is not the owner, buyer will not become the owner. If seller has defective title, buyer gets the defective title. That is called as what? Nemo dat quod non habet. So if seller is not the owner, buyer will not become the owner. If seller has defective title, who gets the defective title? Buyer also gets the defective title. That is called as what? That is what called as the nemo dat quod non habet. But there are exceptional cases where even though seller is not the owner, who becomes the owner? A buyer becomes the owner. Or where the seller is having defective title, a buyer gets the absolute title. What are these? First one, sale by mercantile agent. What agent? Mercantile agent. Now, who is mercantile agent? Any agent in the ordinary custom of trade, he has a right to buy the goods or to sell the goods or to consign the goods or to pledge the goods to borrow the loan. If he has any of these three rights, he is considered as mercantile agent. A mercantile agent satisfying these three conditions sells the goods without having authority or exceeding the authority. Is the sale valid? Yes, valid. Buyer gets the absolute title. What are the conditions, sir? First one, he must be having possession of the goods or document of title with the consent of the owner, and he sell the goods in the ordinary course of business as a mercantile agent, and the buyer acts in good faith without having knowledge of defect in the title of mercantile agent. If these three conditions are satisfied, even though mercantile agent did not have the right to sell the goods, who becomes the owner? Buyer becomes the owner. Next one, sale by joint owner. If there are joint owner or a co-owner, and one of the co-owner is having possession of the good by the permission of the other co-owner, there are joint owners or co-owners, and one of the co-owner is having the possession of the goods with the permission of the other co-owner, plus if the purchaser acts in good faith without having the knowledge of the fact that the one of the co-owner did not have the permission of the other co-owner to sell it, then the purchase is valid and the buyer gets the good faith. Buyer gets the good title. I repeat, out of two joint owners, one of the joint owner is having the possession of the goods with the consent of other joint owner, and having possession is sold to a person who is acting in good faith. The sale is valid. Next one, sale by a person in possession of the goods under a voidable contract. What is voidable contract, sir? As per section number 19 of the Indian Contract Act and as per section number 19 of the Indian Contract Act, any contract which is enforceable at the option of one party, not at the option of other party, is called as what? Voidable contract. So if a person is holding the possession of the goods under a voidable contract, and if he sell that to a person who is acting in good faith before the contract is cancelled, then the buyer gets the good title. Three conditions. First one, The seller must be having possession of the goods under a voidable contract, not under void contract. So this provision or exception is applicable only when the seller is having possession of the goods under a voidable contract, not under the void contract. Second condition, the voidable contract must not have been cancelled by the aggrieved party. And the other party who is purchasing the goods, he must act in what faith? Good faith. If these conditions are not satisfied, if these conditions are what? Satisfied, even though the seller is selling the goods, having possession of the goods under a voidable contract, is the sale valid? Yes, sale is valid. Buyer gets the good title. Next one, sale by one who has already sold the goods but continues to be in possession of the goods. See, after sale, who is the owner? Buyer is the owner. But however, the seller continues to have possession of the goods, and he continues to have possession of the goods and sell them to the person who is acting in what faith? Good faith, who is not aware about the previous sale. Now, who gets the good title? The buyer gets the good title. The second buyer gets the good title. Next one, sale by the buyer in possession of the goods before sale. The goods are already with the buyer under an agreement to sell, not under an option to buy, not under the hire purchase system or any other things. So if he has obtained the possession of the goods under an agreement to sell, not under an option to buy, and if he sell it to a person who is acting in what faith? Good faith, then who becomes the owner? The new buyer becomes the owner. Next one, estoppel. Excuse me. What is estoppel? When the owner, either by his act or by conduct or omission, convinces the buyer or makes the buyer believes that seller has the authority to sell. Let's say I am the one who is the owner of the goods. I make the buyer believe that the one who is selling the goods is having authority to sell the goods, and I convince the buyer to buy the goods. Later, I cannot deny the fact that the seller did not have an authority to sell. I am the owner. Somebody is not having the ownership. I allow him to represent him as the person having right to sell the goods, or I myself represent him as having the right to sell the goods to a third party, and he believes upon it and he purchased the goods. Later, I cannot deny the fact that he did not have the ownership. He had the ownership. Next one, sale by unpaid seller. Goods are sold, payment is not done. Unpaid seller can what he can do? Resell the goods after giving what notice? A reasonable notice. Sale under the provisions of any other act, that is under the in case of pledge. If the pledgee does not receive the payment after giving reasonable notice, what he can do? He can sell it. Pledgee is not the owner, but he is selling it. Whoever buys the goods gets what title? Good title. So these are the 8 exceptional cases in which even though seller is not the owner, who becomes the owner? A buyer becomes the owner. Who becomes the owner? Buyer becomes the owner. Next one, performance of contract of sale. The next unit is what? Performance of contract of sale. What is performance? Fulfilling the obligations. Till now we discussed the contract of sale of goods. अब हम discuss करेंगे. Now we will discuss how the contract is required to be performed. Section number 31 provides that payment and delivery are concurrent conditions. Unless the contrary things is expressed in the contract, the payment and the delivery must happen at the same time. Section 33 is what most important? Delivery of goods. What is delivery of goods? A voluntary transfer of possession of the goods from seller to the buyer. It is called as what? A delivery of goods. There are 3 types of delivery of goods: actual delivery, symbolic delivery, constructive delivery. Physical possession is transferred, actual delivery. When the delivery of goods is made by transfer of something else, like that is by as a token of transfer, that is by delivery of key of the car or by key of the godown, that is called as what? A symbolic delivery. Then what is the next one? Constructive delivery. When the delivery of the goods happens by an acknowledgement of a third party. If the goods are in possession of a third party and where the possession is transferred by a mere acknowledgement of the third party who is having possession of the goods, it is called as what? A constructive delivery. 3 types: actual delivery, symbolic delivery, constructive delivery. Physical possession is transferred, actual delivery. Where the possession of the goods are transferred by a token or a symbol, symbolic delivery. Where the possession of the goods is transferred by acknowledgement of a third party, a constructive delivery. Next one, rules of delivery. Demand for delivery of goods. Who has to apply for delivery of goods? It is the duty of the buyer to apply for the goods. Seller is not under a duty to deliver the goods unless until who applies for it? Buyer applies for it. So the buyer gets the cause of action, that is right to sue the seller only after he makes what? A demand. Place of delivery, if the contract is for sale of goods, immediate transfer of ownership wherever the goods are at the time of entering into a contract of sale. If it is an agreement to sell, then the place at which the goods are produced or manufactured is the place where the goods are to be delivered unless the parties agrees otherwise. Time of delivery, if it is agreed, agreed time, not agreed, a reasonable time. What is reasonable time is a question of fact. Expenses of delivery, any expenses till the time the goods are put into deliverable state, it is a duty of seller. Once the goods are put into deliverable state, it is a duty of the buyer. Part delivery, important. When the part of the goods are delivered in the process of delivery of the whole lot. So in that scenario, a part of the delivery made is also considered as what delivery? Full delivery. But where the delivery is made just with the intent to separate from the bulk, a part delivery is made with the intent to separate the rest from the bulk, it is called as what delivery? Part delivery. For example, I made a contract to deliver 1000 kg of or 1000 units of goods. Because there is a shortage of space in one lorry, I sent 500 kg in one lorry and 500 kg in the other lorries in a gap of 2 hours. So here the part delivery is made in the process of delivery of the whole lot. It is considered as what? Full delivery. The moment I delivered the first lorry, it is considered as what? Delivery of entire quantity. But what if the delivery is made just to separate? For example, I separate 500 units one day and I will deliver them, then remaining 500 units on the next day or after 2 days. This is called as what delivery? A part delivery. Based on this, they may ask question in the examination. Delivery of wrong quantity. If the seller delivers the wrong quantity, it can be short delivery, excess delivery, mixed delivery. Seller has agreed to deliver 1000 kg, but he delivered 500 kg. It is called as what delivery? Short delivery. What buyer can do? Either he can accept and pay for the 500 kg or he can reject the entire quantity. Excess delivery, if the seller has delivered the excess quantity, agreed 1000 but delivered 1500. Now the buyer has what? Option to reject the entire quantity or option to what? Accept the agreed quantity and reject the excess quantity. Next one, mixed delivery, where there is a mixture of goods, where the seller or the buyer mixes the goods with some other quantity. In that scenario, if it is possible to separate, the buyer can segregate it, and whatever the expenses incurred for segregation, he can recover it from whom? Seller. If it is not possible to segregate, he can reject the goods and recover the compensation. Section number 42, rules of acceptance of delivery, important. When the acceptance of delivery is complete, as we discussed, there are 3 scenarios. What is the first one? When the buyer intimates to the seller that he has accepted the goods, that is called as acceptance. Second one, when he does something to adopt the transaction, that is when he consumes it or when he resells it or when he pledges it. Third one, when he keeps the goods beyond what time? A reasonable time. Then also it is considered that the buyer has accepted the goods. Only when the buyer has accepted the goods, what is transferred? The delivery is complete. Next one, examination of the goods. The seller should give the buyer a reasonable opportunity to inspect the goods before he accepts them. So if the reasonable opportunity is not given, then the buyer is not bound to accept the goods. Next one, the buyer is under no obligation to return the goods which he has rejected. He just has to intimate the seller that he has rejected the goods, and it is a duty of the seller to take the goods back. Next one, liability for negligence. If the seller is ready to give the delivery of goods and requests the buyer to take the delivery of the goods, then the buyer should take delivery of the goods. Within what time? Reasonable time. If not, then who is liable? The seller. The buyer is liable for the loss and compensate whom? Compensate the seller. So these are the rules with respect to what? Rules of acceptance of delivery, section number 42. So with these we are done with what? Unpaid seller, section number 46 to 64, 4664. Section number 46 to 64 deals with what? Unpaid seller. First one, let us understand who is unpaid seller. Who is unpaid seller? Simple. If the seller has not received the entire payment, then he is considered as what? Unpaid seller. The seller is considered as unpaid seller if he has not been paid or tendered the whole of the price of the good, or who had received the bill of exchange or any other negotiable instrument as a conditional payment, but subsequently it is what? Dishonored. Then he is considered as what seller? Unpaid seller. I repeat, if he has not been paid or tendered the whole of the price. For example, if the sale value is 1 lakh, but he has been received, he has been paid only 50,000. Then for remaining 50,000 rupees, he is considered as what? Unpaid seller. Or if he has received a negotiable instrument like bill of exchange or a check and it is dishonored, payment is not done, he is considered as what seller? Unpaid seller. If a person is an unpaid seller against the goods, he has three important rights based on which they ask questions many times in the examination. First one is lien. If the goods are with him, he can keep the possession of the goods with him. Second one, if the goods are in transit, he can take back the possession of the goods. Third one, he can resell the goods after giving notice to whom? Notice to the buyer. First one, section number 47. Section number what? 47. What is 47, sir? Seller's right of lien. The seller is entitled to retain the possession of the goods if he is an unpaid seller. In how many situations? If following three conditions are satisfied, you should write these three conditions if they ask question in the examination. What is the first one? The goods have been sold without any stipulation as to credit. Means it is not a credit sale. If it is a credit sale, he has to wait till what date? The credit period gets expired. So the goods should have not sold on credit basis. Second one, even if the goods have been sold on credit basis, the credit period has been expired, or if the buyer has become insolvent. So if these three conditions are satisfied, then the seller considered as unpaid seller and he has a right of lien, that is right to keep the possession of the goods. I repeat, even if the goods are sold on credit basis, but buyer becomes insolvent, obviously it is not going to pay the money. Now seller can exercise the right of lien. But other than that exceptional case, if the goods are sold on credit basis, seller cannot retain the possession of the goods until what is gets over, the credit period gets expired. Next one, termination of lien, when the right of lien comes to an end. First one, unconditional delivery of goods to the carrier. If the goods are unconditionally appropriated to the buyer, appropriate to whom? To the buyer. In that situation, what happens? In that situation, then if the goods are unconditionally appropriated to the buyer, then the ownership is transferred to whom? The ownership is transferred to the buyer immediately. Correct, right? So in that scenario, there is a question of right of lien. Next one, the buyer has obtained the possession of the goods. See, right of lien is a possessory right. If the possession of the goods is already transferred to the buyer, there is no question of what? Right of lien. Next one, waiver. What is waiver? If the seller has given up the right of lien at the time of entering into a contract, then he cannot exercise the right of lien. Estoppel, if the seller has made any third party believes that he doesn't have a right of lien, then he cannot exercise the right of lien. So these are the cases in which a right of lien gets terminated or comes to an end. Next, right of stoppage in transit, section number 50 to 52. The right of stoppage in transit is available only when the buyer becomes insolvent and the goods are in transit and the buyer has not taken the possession of the goods. So, if the buyer becomes insolvent and the unpaid seller has parted with the possession of the goods, he can stop them if the goods are in what? Transit. The goods will be in transit only when the carrier neither act as agent of the seller nor act as the agent of the buyer. He is acting in the independent capacity. Duration of transit. So the duration of transit is from the time the goods are delivered to the carrier till the time the goods are delivered to the buyer. The goods are deemed to be in what? Transit. So if the goods are in transit, who can stop the goods in transit? The seller can stop the goods in transit and he can recover the goods back. When the transit comes to an end, important, the transit comes to an end when the buyer obtains the delivery of the goods after arrival at the particular destination or before the arrival at the particular destination, or if the buyer after reaching the destination of the buyer, if the carrier after reaching the destination of the buyer, he acknowledges that he is holding the goods on behalf of the buyer, then he cannot deny the delivery of the goods. Next one, in case if the carrier wrongfully refuses to deliver the goods to whom? To the buyer. In these three cases, what comes to an end? The right of stoppage in transit comes to an end. And right of stoppage in transit can be affected either by giving a notice or by taking the actual possession of the goods from the carrier. So whatever the redelivery expenses are incurred should be borne by whom? By the unpaid seller himself. Next one, the effect of subsale are pledged by the buyer. See, if there is a contract of sale and seller becomes unpaid seller, but the goods are resold by the buyer, or if he has pledged the good to the buyer, any other buyer, will it affect the rights of unpaid seller? No. So if there is any subsale or a pledge by the buyer, that will not affect the rights of whom? Rights of the unpaid seller. So unpaid seller will continue to have a right irrespective of the fact that the buyer has resold the same to someone else, or he has pledged the goods to someone else for borrowing the money. But there are two exceptional cases where the rights of unpaid seller, that is right to stoppage in transit and right of lien, gets affected. What are they? When the seller has assented to the sale, means he has given a consent for the resale or a mortgage or disposition of the goods made by the buyer, or if he has delivered a document of title to the buyer and the buyer resell them by delivery of document of title to a person who is acting in good faith. In these two exceptional cases, the subsale or a pledge by the buyer will affect the rights of whom? Rights of the unpaid seller. So if he has given a consent for resale, buyer resells, then the new buyer can recover the goods from unpaid seller. He cannot exercise the right of lien or stoppage in transit. Second one, where he has delivered the document of title and the buyer resell them by delivering the document of title to a person who is acting in good faith, then also cannot exercise the right of lien. Next one, section 54, right of resale. An unpaid seller may resell the goods after giving a reasonable notice to the buyer. But however, there are cases where notice is not required. First, in general, notice is must. But there are few exceptional cases where notice is not required. One is if the goods are perishable in nature. Second one is where the right of resale is expressly reserved in the contract itself. But other than these two exceptional cases, if the notice is not given, there are two consequences. First one is if there is a loss on resale, seller cannot recover it. But if there is a profit on resale, he has to give it back to the original buyer. That is why the notice must be other than perishable goods. And second one is where he has reserved the right of resale at the time of entering into a contract itself. Next one, rights of the unpaid seller against the buyer. What are the rights available to the unpaid seller against the buyer? First one, if there is a breach of contract with the seller, by the buyer, then the unpaid seller can sue the buyer for what? Recovery of the price. Second one, he can sue the buyer for recovery of damages for non-acceptance of goods, section number 73 of Indian Contract Act. Third one, he can sue for repudiation of contract and also for what? Claiming the interest for delay in the payment of price. Next one, remedy for the buyer against the seller. If seller breached the contract, then what is the remedy available to the buyer? First one, he can sue for damages for non-delivery of goods, section 73, damages for non-performance of the contract, suit for specific performance. If the goods are of unique nature, where the compensation in terms of money is not the adequate remedy, in those cases, he can request the court to compel the seller to perform the contract specifically. Next one, he can sue for the breach of warranty to claim compensation. He can also sue the seller for repudiation of contract before the what date? Due date. He can also recover the interest. Who can recover the interest? The buyer can recover the interest from the seller for any advance he has already paid. Next one, section number 64, auction sale. What is auction sale? Where the sale of goods happens through the auction or by bidding. Where the highest bidder gets what? Gets the goods. And the person with the hammer is called as what? Called as the auctioneers. Can seller also bid for his own goods? Yes, if he has expressly intimated the same to the fellow bidders. If it is not intimated, it is called as what? Fraudulent sale. What sale? Fraudulent sale. Then in that scenario, if the buyer discovers it later, he may refuse to take the delivery of the goods. When the seller has not notified the fellow bidders that he has a right to bid for the goods either by himself or through his agent, then it is considered as fraudulent sale. The buyer can repudiate the contract if he discovers the fact that even seller was bidding for his own goods. Next one, pretended bidding, where a person does not have the intention of buying the goods, but he tried to raise the price by just participating in the bidding. That is called as what? Pretended bidding. Then the contract is voidable at the option of the buyer. Section 65, effect of tax. See, after the contract is made, before the sale, that is before the transfer of ownership, if there is an increase in the tax rates at the time of transfer of ownership, then the buyer has to liable to pay the increased amount of tax. But if there is a decrease in the tax rate, then the buyer is supposed to pay the reduced amount of tax. I have covered all the important topics of the Sale of Goods Act 1930 in brief in this rapid revision video. If you guys want any video on any other chapter, please drop a comment. I'll be happy to help you guys. Together, let's remove the fear of law and spread the love for the law. Thank you very much. Your CSR Law Earlier.